everybody. How's it going? Just having some problems here. Look, we're definitely reaching Facebook from what I can see. Thank God. God is really good. Last night, just a few minutes after the show, our AT&T internet just went down in this whole neighborhood. It was out all last night. It was kind of very inconvenient for us. But it was down all last night, and they were working on it. It was down all day today, and it just came up shortly before we're going live. So thank God we're able to make the broadcast. For some reason, I'm not able to load the YouTube page. What, is YouTube down? Really? Wait, there it goes. Okay. Now it's loading. All right, YouTube working too. Thank God. All right. Good to be with you. So glad we're broadcasting. Who's in the house? Yehud in South Carolina, Sharon in New Jersey, Stephen in New Hampshire, Shandor in the Bronx, Paul in the Great Northwest, Bella in Florida, Bill in mid-Missouri, Lucy in Minnesota, Belle in Texas, Melissa in Great Neck, Carl in Brazil, Karen in Northern California, Guy in Ohio, Marjorie, we are here in Georgia. Welcome, everybody. Let's light up the darkness. Okay, today we're going to open Mishna number 12 here in chapter 3. Tractate Kiddushin, the 20th volume of the Talmud. And our daf is page Samech, page 65a. And we are just, maybe a quarter of the way down the page. On page 65, and this is all in the context of which witnesses are deemed credible in non-standard situations, right? So normally to create betrothal, you must create the betrothal in front of two witnesses. And if you didn't have two witnesses to betrothal, no betrothal. But we have a special case that a father is deemed credible, usually, to say that he betrothed his minor daughter. But even if a man and a woman betroth each other, they're not the witnesses to that. They need to have witnesses. And so what happens if they don't have witnesses? Is this an uncertain betrothal that's going to require a get to unwind it or not? These are kinds of the issues we're going to be looking at today. Reminder, we are going to have class tomorrow, the regular Friday time, noon Pacific. We'll have class, God willing, tomorrow, God willing, Saturday night as well. Thank goodness for the sake of our class. The schedule, the sun is going down earlier and earlier. So hoping to get on, I think candlelighting tomorrow is like even before 6 here. So maybe by, 7:45 on Saturday night, we could get on the air, 7:45 Pacific. And then I'm going to be out of town next week. No class Sunday through Thursday, and with God's help, be back on the following Friday. Right? But in the meantime, we're having class now, and Friday, tomorrow, and Saturday night, and then I'll be out of town. Okay, let's do this. Mishnah number 12 here in chapter 3. With regard to one who says to a woman, I betrothed you, and she says, you did not betroth me. Now, there's no betrothal because they don't even agree, the two of them, that they're betrothed, but we have this uncertainty, right? He says that he's betrothed. She says, no, we were never betrothed. But according to what he says, he renders himself forbidden to her relatives, right? That's because if he was betrothed to her, and he really was betrothed to her, then he can never marry her sister until this woman that he, was allegedly betrothed to, until she dies, right? Because you can't marry a woman and her sister. Even if you marry and divorce a woman, you still can't marry her sister. If the first woman happens to die, only then could he marry her sister. So when he says, I was betrothed to you, we take him at his word only to the extent that he renders himself prohibited to marry her sister. He is forbidden to the relatives of, Right? He says, I betrothed you. She says, you did not betroth me. So he renders himself forbidden to her relatives, as his claim that he has betrothed her renders himself forbidden to her relatives. And she is permitted to his relatives. Right? She says, we were never betrothed, so, she can still marry his relatives, in accordance with her stance that she is not betrothed to him. If she says, you betrothed me, and he says, I did not betroth you, so he remains permitted to her relatives, but she has rendered herself forbidden to his relatives by the same reasoning. If a man says to a woman, I betrothed you, and she says, you didn't betroth me, you betrothed yourself to my daughter. Well, then he is forbidden to the relatives of the older woman, per his claim that he betrothed the older woman, the mother. And the older woman, the mother, is permitted to his relatives, per her testimony that she was never betrothed to this guy, so she can still marry his relatives. He is permitted to the he is permitted to the relatives of the older woman. And the older woman is permitted to his relatives. He is permitted to the relatives of the younger woman, the daughter, as he maintains that he did not betroth her. And the younger woman is permitted to his relatives, since her mother's statement is insufficient to render her forbidden. She never said anything. According to her mother, she was betrothed, but that's only a single witness, and a mother doesn't have the authority to betroth her daughter, even when she's a minor, the way that a father does. So that would be the outcome of that situation. And similarly, if he says, I betrothed myself to your daughter, and she, the mother, says, no, you betrothed yourself to me, so he is forbidden to the relatives of the younger woman, and the younger woman is permitted to his relatives. He is permitted to the relatives of the older woman, and the older woman is forbidden to his relatives. That's the Mishnah. Now the Gemara. The Mishnah taught that with regard to one who says to a woman, I betrothed you, and she denies his claim, he is forbidden to her relatives, while she remains permitted to his, right? We don't create a betrothal because there are insufficient witnesses to that, but we create enough uncertainty that per their own testimony, we're going to render them prohibited just in case a betrothal was formed. Right, so the Mishnah then provides several examples illustrating this same principle. And so the Gemara comments, and it is necessary for the Mishnah to specify all these cases. And the Gemara elaborates. Why? Because had the Mishnah taught us the law only with regard to himself, i.e. the case where he claims to have betrothed the woman, and she says, no, you didn't betroth me. If the Mishnah had only taught that case, then one might have said that he is not deemed credible at all. Because a man does not care if he happens to say that he betrothed a woman, even if he did not do so, because he can still marry other women. This is by Torah law. A man can have more than one wife. A woman can only have one husband. She can't be married to more than two men. Now, by rabbinic law, no, a man can only have one wife, just like a woman can only have one husband. But that was kind of later rabbinic innovation, rabbinic prohibition, as we see in the Torah. For example, Jacob, right, had multiple wives. Now, that happened before the Torah was given. But according to the Torah, a man can have more than one wife. That was common practice in the ancient world. And what's interesting is even in the times of the Talmud, when it was permitted by Torah law and there was no rabbinic decree against it, nevertheless, in common practice, it was almost unheard of, right? Even at the times of the Talmud, but they're still studying it according to Torah law. And then later, much later, which is still 1,000 years ago, Jewish history is old. So 1,000 years ago, which is still relatively recently in Jewish history, Rabbi Gershom, issued the edict that that's it. Men can only have one wife. And since then, by rabbinic prohibition, men can only have one wife. But still, according to Torah law and what they're discussing here, a man can have more than one wife. So if he says, I was betrothed to this woman, he's not going to be so punctilious, so careful to make sure, that he's saying what is true and not what is not true, the way that a woman would. Because if she says, you betrothed me, then according to her testimony, that's it. Until she gets a get from this guy, she is not free. She cannot go marry anyone. And if this guy disappears before giving her a get, she's going to become an agunah, a stranded woman who cannot get married. So there is an imbalance, and the Gemara is commenting on that. So that's why it says that in a case where the woman claims that she had been betrothed by him, one might say that if her statement was not certain to her, she would not have said it. Since her claim that he betrothed her renders her forbidden to everyone else, it is likely that it is true, and therefore one might think that he should also be forbidden to her relatives on the basis of this assumption, and the Mishnah therefore teaches us that this is not the case. Ultimately, remember, what we keep talking about is that we don't have the normal situation where when people get betrothed, it happens in front of two witnesses and then the fact is established. That's not the case, and we're dealing with this uncertainty. Likewise, with regard to one who says, I betrothed you, and she says, no, you were betrothed to my daughter, not to me, in which case he is forbidden to her relatives, according to his own testimony, but she remains permitted to his, the Gemara asks, why do I need this case to be specified in the Mishnah? This principle has already been established in the first clause. So the Gemara answers, it was necessary to state the second case too, as it might enter your mind to say, since by Torah law the merciful one deems credible a father who claims to have betrothed his daughter to a particular person, perhaps the sages deem a mother credible by rabbinic law, and therefore her daughter should be forbidden based on her statement. The Mishnah therefore teaches us that the mother is not believed with regard to her daughter, the way that a father would be believed with regard to his daughter, again, because he has authority to betroth his minor daughter, a mother doesn't. The Gemara continues this line of reasoning, and with regard to the case where a man says, I betrothed your daughter, and the mother replies, no, you betrothed me, not my daughter. So why do I need this case? What novelty is taught here? And the Gemara answers, since the Mishnah taught this other case of a man claiming he betrothed a woman and the woman replying that it was her daughter, it also taught this last case so that it mentions all of the permutations, despite the fact that this particular case provides no novelty, no new ruling. It was stated that the sages of the Gemara, the Amoraim, disagreed over how the court should proceed in practice with regard to the cases described in our Mishnah. Rav says, now this happened, right? When this really happens, what do? So Rav says, the court forces the man to, Rav says the court forces, right? Now, Rav Steinsaltz elucidate that the court forces the man to give her a get. And Shmuel says the court requests, right? And now Rav Steinsaltz elucidates, this means that Shmuel says the court requests that the man give the woman a get. So the Gemara asks, with regard to which case of the Mishnah is this referring? If we say it is referring to the first clause, where he says, I betrothed you, and she says, you did not betroth me, so then why does the court need to force? There's no ruling of the court forces that is relevant here, nor is the ruling the court requests relevant. Since she is permitted to marry even his relatives, she is certainly permitted to marry anyone else. Why then would it be necessary for this man to give her a get? Rather, the dispute applies to the latter clause of the Mishnah, where the man denies her claim that he betrothed her. Now, to allow her to marry someone else, the court either forces or requests the man to give her a get. Now, the Gemara says, granted, according to the opinion that the court requests the man to give her a get, it is well. Since she has rendered herself forbidden to everyone, one can ask him to release her. But why should the court force the man to issue a get? Can't he say, no, it is not satisfactory for me to be forbidden to her relatives? He was planning to marry her sister. Now she comes forward and says, you betrothed yourself to me. He's like, what are you talking about? I never did that. And she says, well, you have to give me a get, because that's what I remember you betrothed yourself to me. He's like, if I give you a get, then I can't go ahead with my plan to marry your sister. This is right? He was going to marry the sister, and then this crazy other sister comes forward and says, no, he betrothed himself to me, and totally lampoons the, plan of, her sister to marry this man and they mutually agreed to get married. Right now, the crazy sister comes forward and says, no, you betrothed yourself to me. Are we going to really force this man to give the crazy sister a get and therefore render himself prohibited to marry the woman he was intending to marry? You see why there's a problem. So rather, the Gemara offers a different explanation. That's not what forces and requests means. These laws were stated together. What does it mean? Shmuel says that the court requests the man to give her a get. So if he didn't have a plan to marry her sister, then it doesn't make any difference to him, and the court requests it, and he should do it. But Rav says if he gave her the get of his own accord without being asked to do so, but merely in response to her claim, then the court steps in and forces him. Forces him to do what? To pay the ketubah, to pay the marriage contract, right? Because if they were betrothed, then there must have been a marriage contract. And if they're now going to break it off, then he owes her money, right? The money of the ketubah payment. Maybe he was intending to, okay, I'll give her the get, but not thinking, and I got to pay her the ketubah, so he's got to pay that. So by giving her a get of his own volition, he has effectively admitted that he betrothed her, despite the fact that he has not said so explicitly. Consequently, he must also provide her with payment of her marriage contract. It was also stated that Rav Acha bar Ada says that Rav says, and some say Rav Acha bar Ada says that Rav Hamnuna says, that Rav says, the court forces him and requests of him. And the Gemara expresses puzzlement at this statement. How can these two statements be reconciled? Rather, it must be that this is Rav Acha bar Ada is saying, the court requests of him to give her a get, and if he gave her a get of his own accord, the court forces him to pay the marriage contract. Right? If the court has to ask him, and he doesn't do it of his own volition, but the court says, please give her a get, then maybe in that situation, he doesn't have to also pay the ketubah. He's just being helpful. Rav Yehuda says, with regard to one who betroths another with one witness, right? So with regard to people who get betrothed, but they don't do it properly. They don't do it in the presence of two witnesses. They do it in the presence of one witness. Right? Until now, we've been talking about no witnesses. Okay, now we're talking about one witness. So now what changes? Let's see. With regard to one who betroths another in the presence of one witness, one need not be concerned that his betrothal has taken effect. The students raised the dilemma before Rav Yehuda. If both the man and the woman concede that there was a betrothal, then what is the law? Is the betrothal valid? Rav Yehuda did not provide a clear answer. He said yes and no. And the matter was uncertain to him. It was stated that the Amoraim, the sages of the Gemara, discussed this. So Rav Nachman says that Shmuel says, with regard to one who betroths a woman in the presence of one witness, one need not be concerned that his betrothal has taken effect. And this is the law, even if the man and woman concede that they betrothed each other. Right? They didn't have two witnesses, no betrothal. So Rava raised an objection, right? Even with no witnesses, it's not like they said, betrothal happened. There is no betrothal, but, the one who says, I betrothed you, and the other one disagrees. The one who says, I betrothed you, just renders himself prohibited to the relatives. Don't be creating betrothal where there was none. You see there's a penalty. But where even they both say, yes, we betrothed each other, but they only had one witness, no betrothal. Now, Rava raised an objection to this from the opinion of Rav Nachman in our Mishna with regard to one who says to a woman, I betrothed you, and she says you did not betroth me. He is forbidden to her relatives, and she is permitted to his relatives. So Rava proceeds to analyze the exact circumstances of this case in our Mishna. If the case is one where there are witnesses, why would she be permitted to his relatives? Obviously, there was no full-fledged betrothal performed in the presence of witnesses, or she would be prohibited to his relatives. If there were no witnesses at all, why is he forbidden to her relatives without any testimony to that effect? Rather, is it not referring to a case where there was one witness, like we're now discussing? And the Gemara answers, here we are dealing with a case where he said to her, I betrothed you in the presence of so-and-so and so-and-so. Two witnesses, and I'm naming them. But those people went overseas. They're not available to testify, and there's no way of clarifying what really happened. So consequently, there are only the conflicting accounts of the man and the woman. And therefore, he is prohibited from marrying her relatives while she is permitted to marry his. Rava raised an objection to the opinion of Rav Nachman from a different Mishnah in Tractate Eduyos 4:7. If one divorces his wife and she subsequently lodged with him in an inn, right? So if you get divorced, so now you're no longer permitted to each other for marital relations. If before she goes and marries someone else, right, they've divorced, and now they find themselves traveling together, and they lodge in the same inn, presumably in the same room. So now we have a problem, right, where there's a presumption. If they take a room together, I mean, are they really just saving money? This is a couple who used to be married, then they got divorced, now they're sharing a room together. It seems likely that they slept together. And if they slept together after they were divorced, what happens? That marital relation between this couple who were ex-spouses and then got divorced and now slept together, they just got betrothed again. If they're not planning to let that betrothal become full-fledged marriage, but rather to continue to go their separate ways, do we require him to give her another get, another bill of divorce to ensure that she really is free to go remarry? That's the question being asked. So if one divorces his wife and she subsequently lodged with him in an inn, so Beis Shammai say she does not require a second get from him, and Beis Hillel say, yeah, she requires a second get from him. So the Gemara clarifies, what are the circumstances of this case? If there are witnesses who saw them engage in sexual intercourse for the purpose of betrothal, what is the reason that Beis Shammai do not require a get, another get? If there are no witnesses, what is the reason that Beis Hillel require a second get? Rather, is it not referring to a case where there was one witness who saw them engage in intercourse for the purpose of betrothal? Note the language, for the purpose of betrothal. So it does seem like if they just, got wild one night, but they weren't intending to get betrothed, so then they committed a transgression of having extramarital sex, but it didn't actually create a new betrothal. But if they were kind of thinking, you know what, let's just get together, I miss you, we shouldn't be divorced, and they said that, and they slept together, now they might change their mind afterward, but that marital relations for the purpose of reestablishing their betrothal would require a second get. But now we have this issue of witnesses. If there were two witnesses to that, they're certainly betrothed again, they would require a get. No witnesses sounds like no. And one witness is what we're talking about. So Rav Nachman responds, well, according to your reasoning that there was one witness, say that the latter clause of that Mishnah, Beis Hillel concede with regard to a woman who was divorced and that she was divorced after betrothal, that she does not require a second get from him. Right? So there's divorce after betrothal distinguished from divorce after marriage. If they were married, right, they lived together, they slept together regularly, then they divorced, and now they find themselves lodging in an inn together. Well, they're very familiar with each other. It's very likely that they ended up sleeping together. But if they were only betrothed, they never proceeded to the chuppah, they never actually got married, they never lived together, they broke off the betrothal with a get, and then they find themselves sharing a room. Well, we don't have a presumption that they actually slept together because they're not accustomed to each other. They're not familiar with each other in that way. Right? And Beis Hillel conceded with regard to a woman who was divorced after betrothal that she does not require a second get from him due to the fact that he is not accustomed to her. Since he had not previously been intimate with her, since they were only betrothed and never fully married, there is no concern that they engaged in intercourse even though they lodged together at the inn. And if it enters your mind that one witness is deemed credible in this case, what difference is it to me whether it was after her betrothal, and what difference to me if it would occurred after her marriage? Rather, it is clear that the Mishnah is not referring to when there is one witness. And here what we are dealing with is a case where there are witnesses to their seclusion. Their witnesses saw them go into the room together, but there are no witnesses to them actually engaging in intercourse. So the dispute is based on the implications of seclusion, not, actual witnesses seeing them doing the deed. So Beis Shammai hold one does not say that these are the witnesses of seclusion, therefore they are witnesses of intercourse. We don't assume that intercourse followed seclusion. According to Beis Shammai, although there are witnesses that they were secluded, this is not considered to be tantamount to testimony that they engaged in intercourse. And Beis Hillel say, we do say that if there are witnesses to seclusion, we have witnesses to intercourse. Since it is assumed that they engaged in intercourse, she is required to obtain a second get from him. But Beis Hillel concede to Beis Shammai that certainly in the case of a woman divorced from betrothal, then we don't have a presumption that seclusion led to sex. Rather, we only make that presumption if they were formerly married together, then they divorced, and then they shared a room that they must have slept together, and that betrothal is therefore a strong possibility, which would require them to have another divorce, another get. Now, Rav Yitzchak bar Shmuel bar Marta says, in the name of Rav, with regard to one who betroths a woman with one witness, one need not be concerned that his betrothal has taken effect. And this is the law, even if the man and woman both concede that there was a betrothal. And Rabbah bar Rav Huna says, with regard to one who betroths a woman with one witness, the great court says that one need not be concerned that his betrothal has taken effect. Right? There's no betrothal unless there's two witnesses. There might be uncertainty of betrothal that would require a get to unwind it, but we don't have a solid certainty that betrothal was created. Now, who is the great court who made that ruling? Who is the great court? Rav. Rav is the great court, just by himself. And there are those who say a different version of this discussion. Rabbah bar Rav Huna said that Rav said, with regard to one who betroths a woman with one witness, the great court says that one need not be concerned that his betrothal has taken effect. And who is the great court? Rebbe, right? Rabbi Yehuda Hanasi, who, edited and put together the Mishna. Rav Achadvoy bar Ami raises an objection from the following Baraisa. There are two men who came from overseas, and a woman was with them. Right? Now, this is like one of those riddle puzzles, but kind of a fun one. There were two men who came from overseas, and a woman was with them, and they had a bundle with them. So this man says, this is my wife, and this other man is my slave, and this is my bundle. And the second man says, no, the woman is my wife, that other man is my slave, and this, bundle of luggage is my bundle. And the woman says, no. Both of these men are my slaves, and the bundle belongs to me. And so everybody's conflicting with everybody else. So then what would the legal ruling be? In this case, she requires two gets, two bills of divorce, one from each guy. As with each of them, there is uncertainty concerning whether she is married to him. And she collects payment of her marriage contract from the bundle. Even according to their claims that she is married to one of them, now that they have each divorced her, she is at least entitled to payment of her marriage contract from the bundle that is at dispute between them. Rav Achadvoy's objection is like this. What are the circumstances of this case? If the Baraisa is referring to a case where this man has two witnesses supporting his claim, and that man has two witnesses supporting his claim, now that's a really tricky situation, right? Because we believe two witnesses. We don't believe these people who are parties to the case. But if two witnesses came forward and said, well, no, this man and this woman were betrothed to each other. But then another two witnesses come forward and say, no, that woman was betrothed to this other guy. Now we have a real problem, right? We have two witnesses on each side, and the court is going to have to question them very thoroughly and find out what happened. Did the witnesses just make a mistake? Is one pair of witnesses lying? It's going to require a lot of investigation. So, What are the circumstances in this case? If the Baraisa is referring to a case where this man has 2 witnesses and that man has 2 witnesses, can the woman say, these are my 2 slaves and this is my bundle? After all, there are 2 witnesses that one of the men is her husband. Rather, is it not referring to a case where each of the men has only 1 witness? This proves that a betrothal performed in the presence of a single witness is effective, as she requires a bill of divorce from each of them, right? So if we said that a betrothal with only 1 witness is not a betrothal at all, why does she require this get? Now, there's a difference between establishing betrothal with certainty and with uncertainty, so let's see if that comes to bear. The Gemara rejects this opinion. How can you understand it that way? In a situation involving 1 witness, in the face of contradicting testimony, as in the case here, where another witness claims she is betrothed to the second man, is a single witness deemed credible at all? Rather, one must understand this case as follows. Everyone agrees that with regard to permitting her to marry all other people, she is permitted even without a get. And here, this is what the Baraisa is saying. She requires 2 gets in order to collect payment of the marriage contract from the bundle. And this ruling is in accordance with the opinion of Rabbi Meir, who says, even movable property, not only land, is subject to a lien when it comes to payment of a marriage contract. Consequently, to collect from this bundle, which has 3 claimants, the 2 men and the woman, consequently, to collect from this bundle, which has 3 claimants, the woman must receive a get from both men, thereby obligating them to give her payment of a marriage contract. So the Gemara asks, what conclusion was reached about the case of one who betroths another in the presence of a single witness? Rav Kahana said, one need not be concerned that his betrothal has taken effect. Rav Papa said, one need be concerned that his betrothal has taken effect. Rav Ashi said to Rav Kahana, what is your opinion that leads you to claim that there is no concern that his betrothal has taken effect? It must be that you derive it by means of a verbal analogy from the word devar, matter, written with regard to forbidden sexual intercourse, and the same word, devar, matter, written with regard to monetary matters. The Torah states concerning one who desires to divorce his wife because he has found some unseemly matter in her, Deuteronomy 24:1, a reference to adulterous intercourse. And with regard to monetary matters, it states, at the mouths of 2 witnesses or at the mouth of 3 witnesses shall a matter be established. And from this we learn that a matter in the realm of prohibited sexual unions, or just marriage law generally, a matter is established by the testimony of 2 witnesses. So Rav Ashi asks, but if so, just as there with regard to monetary matters, the legal status of the admission of a litigant is similar to that of 100 witnesses, and it renders him liable. If he admits it, we make him pay. So why not say here, where one of the litigants admits that he was betrothed, that we make him pay the marriage contract, even without 2 witnesses? And this would mean that if the man and the woman both admit to the betrothal, okay, so they should be liable to bear the consequences of this claim. And Rav Kahana said to him, there is a difference between the 2 cases. There, with regard to one who admits that he owes money, so this admission does not act to the detriment of anyone else. Whereas here, if 2 people say they were betrothed to each other, there is detriment to a third party. Who? Well, their confessions render them forbidden to each other's relatives, which means that their claims affect other people, unlike the case of one who admits that he owes money and then we make him pay. So the Gemara relates that Mar Zutra and Rav Ada the elder, the sons of Rav Mari bar Isur, divided their shared property between them. And they came before Rav Ashi, and they said to him that they had the following dilemma. The merciful one states, at the mouths of 2 witnesses or at the mouths of 3 witnesses shall a matter be established. So why do we say that 2 witnesses are required? So that if the parties involved wish to retract from their agreement and say that it never happened, they cannot retract from their agreement. And as we will not retract from our agreement, we do not require witnesses to establish our division of the property, or perhaps the matter is established only through witnesses. In other words, perhaps the witnesses do not merely provide proof that the division occurred, but they are a constitutive factor in its establishment from a legal perspective. And Rav Ashi said to them, witnesses were created only for liars, and they are not needed to establish the matter. If no one denies the transaction, it remains in effect. So interesting, it's not that a division of property between two people, which normally to establish that, a contract was signed and that everyone agreed to it, in court later, it's only going to be provable if there were two witnesses to it. But that doesn't mean that if there's no witnesses, the two people aren't bound in this agreement. If they both agree and don't contest it, there's no litigation, of course it's a binding agreement. Now, with regard to a related issue, Abaye says, if one witness says to someone, you ate forbidden fat, a sin, right? Eating something that's not kosher. And that one, the subject of the testimony, remains silent and does not deny it. So then the witness is deemed credible, and the person in question must bring a sin offering for eating this prohibited food, right? But didn't we just say that you can only establish something that's going to lead to a penalty by the testimony of two witnesses? Now you're saying, well, if there was one witness and the guilty party doesn't deny it, then he has to bring the offering. Now, this is not really a monetary matter. There's a monetary component because he's going to have to pay for that offering. But this is not the same as a contract dispute between two people. This is whether this person has to bring a sin offering or not. And the Tana, right, the rabbi of the Mishna, of that particular Mishnah, also taught in Tractate Karisos 11b, if one witness said to someone, you ate forbidden fat, and that person says, I did not eat it, well, then that person is exempt from bringing an offering. So one can infer from this that the reason he is exempt is only because he said definitively, I did not eat, which indicates that if he was silent, the witness is deemed credible. And Abaye says that if one witness says to someone, your ritually pure food was rendered impure, and that person remains silent, then the witness is deemed credible. And the Tan of the Mishnah also taught, if one witness said to someone, your ritually pure food was rendered impure, and that person says, no, it was not rendered impure, then he is exempt. And the reason he's exempt is only because he said definitively that his food was not rendered ritually impure, which indicates that if he was silent, then the witness is deemed credible. And Abaye further says that if one witness said to someone, and now we're at the top of 66a, your ox was used by a man for an act of bestiality and is therefore unfit to be brought as an offering, and the other, the owner of the ox, is silent, then the witness is deemed credible. And the Tan of the Mishnah also taught, and with regard to an animal that was used for a transgression or that killed, if this is attested to by one witness or by the owner, he is deemed credible. And the Gemara clarifies the case. What are the circumstances of this case of the Mishnah where the knowledge is established by one witness? If the owner admits to the claim, this is the same as by the owner. Rather, is it not referring to a case where the owner remains silent? And so the Gemara comments, and each of these statements of Abaye was necessary, as had he taught us only that first case where the witness said that someone ate forbidden fat, one might have said that he is deemed credible for the following reason, were it not for the fact that he himself was convinced that he had committed a transgression, he would not commit the transgression of bringing a non-sacred animal to the temple courtyard on the basis of the testimony of one witness. Consequently, his silence is evidently an admission. If you don't owe an offering and you're bringing it as a sin offering, I guess that's problematic. You might have some kind of a stipulation that if you are uncertain whether you owe a sin offering or not, you don't bring a sin offering. Then you bring the guilt offering for uncertainty. But if the witness said, your ritually pure foods were rendered ritually impure and the accused was silent, we would say the reason that he is silent and refrains from denying the claim is that he thinks he is not suffering any significant loss. as the food is still fit for him to eat on his days of ritual impurity, because he is not required to destroy ritually impure foods. And had Abaye taught us only the case of your ritually pure food was rendered ritually impure, we might have said that the reason the witness is deemed credible is that he causes him a loss on his days of ritual impurity, and therefore his silence is tantamount to a confession. But in the case of his ox was used by someone for an act of bestiality, the owner of the ox can say, with regard to his animal, not all the oxen stand ready to be sacrificed as an offering on the altar. So perhaps one would think that the owner does not bother denying the claim because he merely forfeits the possibility of sacrificing this particular ox as an offering, which he considers an inconsequential matter. It is only there where two witnesses to the act that the animal is put to death, whereas here there was only one witness, and it is therefore necessary for Abaye to specify all these cases, right? So generally, what have we learned? For almost everything to be established legally, we need two witnesses, but there's certain areas like a father betrothing his minor daughter, or when it comes to offerings where there's going to be, a heightened, a more stringent requirement to make sure that an animal is fit to be brought as an offering, where the testimony of a single witness combines with the silence of the one involved could establish the matter. But these are exceptional cases, and that's why Abaye had to spell out all the exceptional cases. Okay, that's what I've got for us today. I should have said, if you got questions or comments, get them in. So while my page is reloading, I'll remind you we have class tomorrow, Friday, regular time, noon Pacific, and Saturday night, probably about 7:45-ish. And then from Sunday to Thursday, there's going to be no class because I'm out of town, and we'll resume a week from Friday. Okay, so just one question, it looks like, from Sharon. I'm not clear on why, if both parties agree that they are betrothed, why do they need the affirmation of witnesses? It doesn't seem like the witnesses are called for in some of the scenarios we have studied up until now. It's a really good question. I mean, when would it really come up? If they both agree that they're betrothed, right, and now they're going to proceed to the chuppah and get married, who's going to question that? But I guess maybe we have a situation where they concede that they were betrothed, they want to proceed, but then someone else comes forward and says, whoa, you guys can't get married because of some other circumstance, I don't know what. And they're like, oh, okay, we can't get married, but I guess I have to give you a get, and you're going to become prohibited to my sister, etc. And then the judge says, well, no, actually, the betrothal that you think is a betrothal is not a betrothal. You don't have to give a get. You don't have to pay the marriage payment. You don't become prohibited to her sister. Where people think it's simple, but the law is more complicated than they think. Maybe that's where we would need to have this established. That's off the top of my head. That's what I've got for us today, and with God's help, see you again tomorrow, Friday, the regular Friday time.